number 75, Expel Ortiz versus Breslin. Good afternoon, counsel.
Good afternoon, Your Honors. Will Page, Legal Aid Society, on behalf of Mr. Ortiz. I think, as you've heard from my colleagues, the narrow constitutional question that's in front of the court is whether docs can speculate about the existence of compliant housing and use that speculation to preemptively violate these vested liberty interests and to do so against those individuals that are homeless. What we're hearing Your Honors asking is what alternatives are available. This case is all about the different alternatives that are available. And docs has not availed themselves of any of those. Could DHS house these individuals? Let's find out. DHS, Judge Wilson, is not violating the consent decree because DHS is never getting the opportunity to have these individuals present themselves. And that's what the Bonilla Court specifically found, was that if these individuals presented to shelter intake, DHS would find housing for these individuals. It's not really a question of what type of shelter beds are currently available, because the Callahan consent decree establishes that New York City is a right to shelter city. They would have to use some means to find shelter. Indeed, DOCS has those alternative means too. They have emergency hotel funding. DHS has been very creative in handling this COVID crisis and finding whole new ways to shelter individuals who need to be sheltered. Let's find out what kind of creative solutions they could employ that would not violate.
After the consent decree, did this arrangement between DHS and DOCS come to be?
Are we talking about in 2014, Your Honor? When DHS tried to work with DOCS?
The consent decree was, no. What?
You're asking about Callahan consent decree?
Yes.
In the mid-early 1980s. Yes, Your Honor.
Okay, all right. So, and the agreement to limit it to a certain number of people, when did that come into effect?
That started in 2014 when DHS agreed with DOCS's perspective to have a containment strategy. DOCS wanted to concentrate individuals in New York City because, let's face it, how else can you house people in New York City if they're not concentrated? So DOCS wanted to do that, and DHS, which is in this memorandum which I reference in the briefs, DHS came together and said, okay, we'll do our best to help you with that, and there are about 3 or 4 shelters where we can put these people. From our experience, the majority of them are Ward's Island. And so they've concentrated them, and they've agreed to, for administrative ease, to have 10 a month. And that number hasn't changed. As these numbers have grown, when Ms. Merdekhaeva was here last time and let you know it was 175 people, well, now it's 250 people. So how many people is enough?
Is there any evidence, I think it's similar to the question I asked before, is there any evidence in the record as to, perhaps in the 1980s, everybody thought there were enough beds, and so there was this consent decree. Is there any evidence in this record, in this case, that DHS could actually comply with that today, given the understanding that there's no longer an understanding that all shelters are available to people with SARA conditions?
I think the Bonilla
Court... And the
Court...
numbers of people that are in that situation now. Is there any evidence in this record about that?
Well, I think the Bonilla Court, and we relied below to the RIC Court on the Callahan consent decree and the regulations that provide housing for even those who are sex offenders. And I think the Bonilla Court relied upon Ms. Yvonne Tinsley Ballard's testimony.
We would have to accept that that testimony is before us.
Well, I think the right to shelter is pretty fairly established. The Bonilla Court just hammers it home and makes it excruciatingly clear that they feel that the Callahan consent decree includes those who are subject to SARA.
I guess my question is more of this practical one. So the right to shelter may exist, but as a practical matter, may not be able to be complied with.
Well, I think, Your Honor, that's why I was mentioning that DHS uses other alternatives in its arsenal, and so can DOCS. They seem to be spending approximately $70,000 a year to keep these individuals in prison. So that money, I think, could easily be spent on finding someplace to house them.
The reality is, when you have a consent decree, you will have times when people do not comply with their obligations under the consent decree, and then the attorneys go in, they point out the flaws, they either come to some other understanding or people come into compliance, or they end up going to court.
That's correct.
That is not about what DOCS is doing. That's about whether or not DHS is complying with its consent decree. DOCS doesn't get to decide on its own whether or not DHS can, will, should comply with its obligations that it signed off on decades ago.
But DOCS has to release them to find that out.
But in any event, just to be clear with your response to Judge Stein's question, although I understand you're referring to the Bonilla decision, certainly it's a decision, one can look at it for what it's worth, but I understood really your arguments were based on the legal commitment of DHS pursuant to its own consent decree.
Yes, and the consent decree specifically says present to shelter intake. So that is why we can't sue DHS. That's why DHS is not a party to these proceedings, is because they've never presented to shelter intake so as to trigger the consent decree, so as to allow suit. And so they are heading off that ability.
Can I, before you go off on another point here, these broader policy questions are interesting. Some of it seems to me it's outside the record because we're struggling with what's admissible and what isn't, but isn't this, the ultimate question in this case we're talking about is continued incarceration. The factual point is that this individual has reached their maximum release date. Is that correct?
So Mr. Ortiz was held for 17 months at his conditional release, and then 8 more months at his maximum expiration. So he spent 25 months in
So the short
prison.
answer is yes, he's reached
Yes.
his maximum release date, right?
Correct.
Okay, so this isn't a parole case.
Well, he has a term, so he has 10 years of incarceration that might be 8.5 if he's good, which is what happened. And then he has 5 years of post-release in the community supervision. And so, correct, it's not a parole case like Mr. Johnson, but it's a community supervision case.
Right.
And so docs,
Even though there's no right to conditional release, the question then becomes for the court is, after you've reached your maximum release date, how does that right change, right?
absolutely.
And how does it change?
Well, so the fundamental liberty to be released from confinement is the oldest core liberty that's recognized by the Due Process Clause. The most conservative justices of the Supreme Court, Justice Thomas, for example, would limit substantive due process principles only to that freedom from confinement. So the ability for the state to incarcerate someone and restrict that fundamental liberty, which never disappears, right, that is based on the sentencing scheme. And while there may be no ethereal right to conditional release or to parole, once it's been granted, then those restrictions are diminished. That's when the fundamental right is present and must, any restriction on it has to be subject to strict scrutiny. And if it weren't subject to strict scrutiny, think about the opposite situation that would occur. The Supreme Court has recognized a number of other fundamental liberties, the right to associate with your family, your child, your spouse. So those, which are subject to strict scrutiny when you're on supervision, could just be wiped out because they'd never let you out to begin with. That can't be the case.
All right, when he was on his PR, was there any violation besides?
Mr. Ortiz never intended to be homeless, no, Your Honor. Mr. Ortiz did not violate something that would have allowed the revocation of his good time, nor did he do anything that would have allowed the revocation of his supervision. And that's why docs never invoked those procedural avenues. They did this with no process whatsoever, as we explained to the writ court. So that's why this is a substantive due process question, because they invoked no process and they completely eliminated the right. And the reason it's a cruel and unusual punishment is because they're only doing this to the people that are reliant on shelter, right? The Supreme Court has said in Robinson versus California that the Eighth Amendment prohibits punishment based on your involuntary status. So while Mr. Ortiz was residing at the residential treatment facility, he could not leave the facility to see his family. He could not leave the facility to get gainful employment. He could not do any of the things that the Supreme Court in Morrissey explained is the freedom of a parolee, someone who's able to be part of the community, right, and regain his life. And the
Thank-
only thing he needed to do, I'm sorry, Your Honor, I just want to finish. The only thing he needed to do was to present himself to shelter intake, and they thwarted that.
Thank you. Counsel?
May it please the court, Esther Merdukayeva for the respondents. I'd like to begin with the substantive due process claim. It is subject to rational basis review. Mr. Ortiz has no fundamental right to serve post-release supervision in a manner that is different from what the legislature has indicated. The liberty interest of someone on post-release supervision is not absolute. It is conditional, and it is conditioned by the ways in which the legislature has designed a scheme of PRS. And there are two important parts here that
So let me ask this. How does he get out? If he hasn't violated, he's not being held in violation of any condition, how does he get out of PRS? How does he get out of the residential treatment facility?
He would be out of...
Just stick with that question.
Sure, he would be
How does
out
he
of the
get
residential treatment facility by finding SARA-compliant housing, which would permit him to comply with his conditions of post-release supervision. So one of the restrictions that the legislature has determined to impose on people on PRS is...
Why won't docs let him try by presenting himself to the shelter system in the city?
Well, I think, Your Honor, I have several answers to that. The first is that it would not be rational to require docs to transport people to shelter intake without confirming that DHS can or will accept those people. And
Well,
it would be...
why would you think they can't if they've entered a consent decree, that they will provide shelter to those who present?
Well, Your Honor, I think DHS's representations in the Alcantara case, to which they were actually a party, are really instructive here. In the Alcantara case, what DHS represented is that the 10-person per month policy, in their view, is consistent with their obligations under Callahan, that the 10-person limitation is a rational way
You ought to be careful about arguing what DHS said in some other case if you want us to take your motion seriously.
Well, Your Honor, I think what my reference to the Alcantara statements are intended to show is that it is impossible to resolve factual questions about what DHS would or would not do when presented with someone at shelter intake by looking at records from 2 extra record proceedings. What Mr. Ortiz is asking this court to do is actually quite extraordinary. He is asking...
But you're assuming that they're not going to comply with their legal obligations under a consent decree. I mean, I'm not understanding the rationality of that.
Well, again, Your Honor, what DHS has represented to docs is that they will take the 10 people per month. There is no evidence, even in the Bonilla case. I think the Bonilla judge was very careful to say that the decision was limited to the one person. In the Bonilla case, what the evidence showed is that there are an average of 4 open spots in SARA-compliant shelters per night. And the DHS official even testified in Bonilla that, quote, she could not state exactly how many SARA-compliant offenders they would be able to accept. That is at C-156. And admitted that DHS has adopted a policy of accepting 10 SARA-restricted persons per month. Now, whether or not that is consistent with DHS's obligations...
Let me try this hypothetical. Let's say you had an individual who's transgender, and the city said, well, we know there's a law in the city that we can't discriminate against someone who's transgender, but we just can't assure you. We just can't make the promise to you that we will not do that when they come into the shelter. Is that a basis not to release the person who's transgender? Because the city says, I know we're not supposed to discriminate, but we just can't promise that we won't.
Well, Your Honor, I don't think that hypothetical is analogous to what is happening here, because
Well,
the
that's why it's a
position...
hypothetical.
The position that DHS has taken is that this policy does comply with its obligations under the Callahan Decree. That's at addendum pages 17, 24 to 25, and 63 to 64. So in the Alcantara case, DHS took the position that this policy is consistent with its obligations under Callahan, and it even said that this policy allows it to meet its obligations under Callahan.
Okay, so let's change my hypothetical slightly, and the city says, we don't think we're violating any rights of someone who's transgender if we don't accept them into the shelter, regardless of what the law says. We just think we'd be in compliance.
Well, Your Honor, if the state was under an obligation to release people only to SARA-compliant shelter housing, and it did not have confirmation that there was a SARA-compliant residence for that person to go to upon release, the state cannot release that person. I think that's what this court said in Gonzalez, that whatever the city's obligations may be, from DOCS's perspective, DOCS has an obligation to enforce SARA, which means
So would you consider this a punishment, this person who's can't meet the SARA rule? Is this a punishment?
No, Your Honor, and we think the second...
Is it the basis of a violation of a PRS condition?
It is not, Your Honor. The second department...
So let me just stay on that then, all right? So it's not a punishment to lock somebody up in the same jail that they were in for the 8.5 years before.
Well, the RTF is a different facility and is subject to different rules than other types of correctional facilities.
They're pretty much the same though, right? I
This-
mean,
the- an
intellectual honesty is always a virtue on these things. It doesn't always win you the case, but there's a certain clarity
Well-
that we need when we're looking at these things, and it's hard for me to see much difference.
Well, Your Honor, what I would note is that the legislature was very well aware of what an RTF is.
No, but that's not
because-
what I'm asking you, not what the legislature was aware of. I want to know, this is an Eighth Amendment case, is this person's being kept incarcerated, and one of the principles we look at is whether this can be considered a punishment. Is this a punishment?
Well, Your Honor, the reason for why people like Mr. Ortiz are housed in the RTFs is to facilitate compliance with SARA. And SARA itself is not punitive. I think courts have been consistent in saying that...
So if I understand you correctly, then you're saying, no, it's not a punishment.
Correct. It is not a punishment. This housing is used to facilitate compliance with SARA, which is itself not a punitive condition. It is intended, the statute was passed to
And
protect...
Let me just, because your time's almost up, and we got it. So the violation then is the violation of the SARA requirement, that the prisoner can't meet the SARA requirement because he can't find available shelter, right?
The individual would not be able to comply with SARA, and DOCS has its own obligations under SARA, which is not to release people without ensuring that they have SARA-compliant housing.
Okay.
Thank you, counsel. Mr. Page, I took the liberty of reserving 1 minute of rebuttal time for you,
I appreciate that, Your
Care
Honor.
to exercise
Slipped
that?
my mind. I would love to.
Okay.
I would just like to say, it's interesting that we fall back to the rationality of SARA and the rationality of imposing this condition, because that's not what we're talking about. We're not talking about what it's like when you're out on the street experiencing the liberty that you're entitled to. We're talking about what DOCS keeps saying that they're doing, which is holding you in the same prison so that they don't have to violate
Well,
you.
do you agree that if, say, let's just take Queensboro, was operated in the way that, there's been some discussion about how a residence should be operated as an RTF, then we wouldn't be talking about punishment here. Is that? Do you agree with
Your
that?
Honor is talking about if 7310 was interpreted according to its plain words as a residence where you could come and go, then absolutely.
No, I'm just
would solve the
applying it
problem.
to your argument about what is required under the correction law.
Yes, I think 7310, if properly interpreted, according to the amicus that PLS put in McCurdy, and according to the arguments that we presented to the writ court below, if it were interpreted as a residence, which again, the plain words between 7310 and 7045.3 are quite different. 7045.3 talks about participation in a residential treatment facility and its programming. It doesn't talk about using it as a residence for persons. And if 7310 really means what it says, and it's a temporary stopping off point that can be a shelter, then the individual could present themselves to DHS intake, and we could really find out whether or not, as they presented to the Bonilla court, they would house all these individuals, which is what they said they would do.
Thank you, counsel.
Thank you, Your Honor.